you from all the uncertainties. It gives you the right to dictate how you want to be buried, what kind of funeral, do you want the way you want to be washed, Jazakallah khair, the way where you want to be buried. When I started practicing back in 1987, it used to be very simple. That you go, either you do it online or you go to a lawyer and they prepare what's called a simple will. And it's just that simple. If I die, everything goes to my wife and kids. If they're not around, it goes to my mom and dad. Or if they're not around, it goes to my brothers and sisters. Simple will. But now you can custom make a will. And it's for free. Alhamdulillah. We have it here at INT. A lot of the masajid have it. ISNA has it on their website. You don't have to go to a lawyer if you don't want to. And we'll go through the requirements of what a valid will is and what you will need if you do need to go to a lawyer to avoid such things as the probate tax, the death tax. And that's very important. That's one of the very limited things that I want you to leave here with. The need for a will and how to avoid the uncertainty, how to avoid the taxes. Because that's the number one and number two reason for having a will. So when you come right down to it, okay, you get the question, do all my assets go to the government? The kids and the wife are saying that they want to bury the deceased in a non-Islamic way. Or the other third scenario that we get as a preliminary matter is someone probably well known in the community or well known to his business or well known in his company passes without a will. And he leaves behind a wife and young ones. But there's no instruction, there's no will, there's no instructions, and then it's almost a full-blown investigation to find out what he owned, what he owed, where are they, what banks, and you're never sure that you catch everything because there's no roadmap. The will give you a roadmap. You can leave, it's just like you can leave it as a financial statement. I have an account at XYZ, I have a house here, I have rental property here, I owe so-and-so so much money and I promise to pay him or her by this date certain. There's a roadmap. There's no guessing. There's no need to go to a lawyer. There's no need to go to an investigator. There's no need to go to a CPA. It's all right there in Exhibit A. I owe and I own this thing. And the beautiful thing about Texas law is it allows you always to amend and update your will freely. You can do it anytime you want. All right, so how do I, me and technology. Where's my IT help? I need to go through these slides real quick. All right, while we're doing that, will under Texas law is a very simple document. Has to be in writing, has to be signed, and you need to have two people, two witnesses. Everybody here, most of you know the idea of conflict of interest. You shouldn't hold two positions where someone can come in and say, oh, by the way, this is my son Muhammad. He's not a lawyer, but he's an engineer. Alhamdulillah, he's here to help me. I do have two children that are lawyers, and they developed this they helped all the research and the PowerPoint, but one had to travel overseas and one fell ill last night. So, alhamdulillah, I want to thank Muhammad for taking time out of his day to come in and help me put this together and help me with the program. Jazakallah khair. So, Texas law is very simple with regards to a will. You just need a document, and you can write it out yourself in your own handwriting, and it's valid as long as it's your handwriting and it's signed and it's witnessed by two people. So let's go back and start from the very basic. Every single one of us is going to pass through this door that's called death. And when this person dies, me, you, our sister, anyone, there's two ways you could die. You could die intestate, no will, or you could die with a will. If you die intestate without a will, what happens to your distribution? Can we go to the graph where the Texas distribution schedule is? Now, before that, yeah, that one. So the government does it. If you're married and you have kids, your wife and kids, in accordance with the Texas probate code, get the property. Now, unlike Mr. Balfour in 1948, you could not give away something you do not own. If you don't, Texas is a community property state. From the date of marriage, if you are married, DM till DD, the date of death or the date of divorce, everything acquired in this period is community property. What that means is you own an undivided 100% interest in this property, and so does your wife. Doesn't mean you own 50%, she owns 50%. You own an undivided 100% interest in this community estate. Exceptions, Texas law has exceptions for everything. Anything you get by inheritance, ya Sheikh, is your personal property. It's not community property. Anything you get by gift is your personal property. Anything you get from a recovery from a personal injury is separate property. And anything you get from property that you owned before the marriage, say you own a rental house and you get $1,000 a month from this, as long as you keep that money separate, it's your separate property. If you commingle it into a joint account, it becomes community property. So community property is here. What can you bequeath? What can you, in your will, give away? You can give away your portion of the community property. But you can't give away, if you have real property, your spouse, husband or wife, they get the right for life to own that property. In other words, you have a house. You have a wife and 2 kids. You can't give the house to your uncle so-and-so. Your wife has a life estate in that house, and after her death, if you have a will, you can give it to anybody you want, and if you don't have a will, Texas law gives it to your kids. So if you die without a will, there is a distribution schedule. And wallahi, if you compare it to, we have the Islamic distribution schedule, and you can get it from the office, and it's on our website. It's not identical, but it's very similar. If you die with a wife and kids, this happens. This is our distribution schedule. It's similar to Texas law. If you are unmarried, you have kids, this happens. If you are married, you have no kids, this happens. If you are not married and you have mother and father, this happens. And it's, alhamdulillah, the Islamic distribution schedule right out of the Quran, very specific, cannot be argued with, developed by ISNA, improved by IANT, and is available for free on all the websites. You don't have to go to a lawyer, it's right there. So, we've answered question number 1. If you die in Texas without a will, the government, unless you die with no wife, unless you die with no kids, unless you die with no mother and father, unless you die with no brothers and sisters, unless you die with no aunts, uncles, or nephews or nieces. As we say in Arabic, you are a leaf that's cut out from the tree and there's nothing, no one, anything around you. You are one and only one. There's a possibility that your property can be touched by the government, but not taken by the government. But if you have any of those descendants or heirs at law, they take. Now, that's what happens if you die without a will, which you shouldn't do, because what happens? Then there's an issue as to how your burial and funeral will be. There'll be an issue as to who takes care of your estate. Then the main thing that happens is, if you die without a will, you must go to probate court. And everything you do will be ordered and taken care of by the judge. What happens there? Say you have a decent estate, and now any estate over $500,000 or $1 million is a decent estate. The judge will appoint an administrator, not you, but if you have a will, you can appoint your own executor, your own administrator. If the judge appoints one, and if you have a decent sized estate, the judge will make him or her post a bond. You see all the unnecessary steps, all the unnecessary costs, all the unnecessary stress to your loved ones. That administrator cannot buy, sell, go into your bank account, go into your safe deposit box, sell your car, do any of that stuff without a court order. So if you die without a will, your your estate gets probated. The probate is controlled by the court. The court must order everything. The administrator must file a tax return that shows all of your assets. They must file an accounting. They must ask for permission to open and close your estate. All of that costs time, money, and stress. If you have a will, Texas law allows you to name an executor and a backup and as many backups as you want. So what's an executor? An executor is the person that you trust to bury you, pay your last rites expenses in the way you determine and you put in the will. You say, I want to be buried in Restland. I have bought lot 4, B12. I want to be washed and my body wrapped in white cloth with no stitching, no perfumes, and my face facing Mecca. That's what we put in the Islamic will, available here for free. You have absolutely every right. You say, I want to be buried in Beirut or Syria or Palestine if you can get there, or Jordan or Pakistan, wherever. You can designate that in your will. You can advise your executor, and your executor can be your wife. Here, there's a little exception to the conflict of interest, because who's going to inherit you? Most likely your wife and kids. But you can also appoint your wife here, or the wife can appoint her husband as the executor. Texas law allows you one of two things. You can have your executor be what's called independent, which is the best thing. If you trust them, let them be independent. Independent means they don't have to go to the court and ask for permission to do anything. They have what's called letters testamentary, which is a power of attorney from the person that died. Take care of my properties, take care of my estate, take care of my taxes, take care of my debts, take care of everything. You don't need to go get permission, and I don't need you to go put insurance and put a bond through the courts. That is a great privilege. If your wife predeceases you or is unable to serve, she's ill or any other reason, you have a backup. And if that person is unavailable, you have another backup. This is a great benefit, and use it, because you can determine who buries you, washes you, how they bury you, which is important to avoid question number 2 that we get from the community. Brother so-and-so died and his wife wants to bury him through the church service. Well, brother, did he leave a will? Well, brother, did he leave instructions with his kids? And then you have to go through a terrible legal process, and so you avoid all that. If for some reason some people have complicated lives and they say, no, I don't want my administrator to be able to freely do everything. And then we'll talk about trusts here in a second, and you can control a lot of the stuff through trust. But, excuse me, you say, I want my executor to be dependent. If you want them to be dependent, means going through the court, you can. Dependent, everything is controlled, go through the courts, you file the tax returns, you file the financial statements, you file the application to close, everything is formal and everything is done formally. Now, those are the two most important things, independent or dependent executor. That's the first thing that you put in your will. You choose 3 or 4 people that you trust, and you put them in the position to, executor means to execute your last wishes, your wishes. Second thing is, if you have kids under the age of 18, minors, the law does not allow them to take property. They're minors. So you must appoint a trustee over their property. You can do that in your will, a simple will, the will that we have here. You can establish a trust, and it could be a simple trust. And you can say, I want my kids to take so much at 18. Some people say, at 18, they haven't reached that level of maturity where they may be able to deal with, $300,000, $400,000, $500,000, $600,000. I want them to take 20% at 18. Then I want to give them enough for their college years. Then after they graduate, they probably need to buy a house. Then they're probably going to get married. So you can stair-step it and customize it the way you want. But you appoint same thing, and it could be the same 3 people that you put as executors. They could be your trustees. Trustees do what? They take care of the money that goes to the minors under the conditions that the person who establishes the will sets. You could say, I want them to do X, Y, Z. I want them, any condition that is not against Texas public policy, you can put in your trust. And you can name the same three people. Sometimes the executors are people that want to do things like pay your last bills and help wash you and help bury you. And sometimes you want to appoint the trustees, people more readily cognizant of the fact as to how to deal with money. So you have the option of appointing same three people or different three people. The last three people is if you have kids under the age of 18, you must appoint guardians. Another benefit of having a will. You designate who you want to raise your kids and how to raise them. Again, it could be the same three people. It could be your wife and your brother, your sister, her brother, whoever you designate. Could be the people that are guardians of the body of the children until they become adults, which is in Texas the age of 18. Now, another important thing is you can control with conditions who takes after your death. This is a big issue in our community, is people marrying outside the faith. Some people put in their will that if any of my kids marry outside the faith, I don't want them to take any part of my estate. Or I want my son or my daughter to get this much when they get their college degree. You can put conditions that you feel are, first, they have to be legal. They can't go against Texas public policy. That you feel are important to you in your lifetime for the stuff that you work for in order for your beneficiaries or heirs at law to take. So you can put those conditions. Now, we saw right there, this is the simple distribution schedule under the Texas Probate Code if you die without a will. If you die with a will, what's the distribution schedule? You decide. Or we have the Islamic distribution schedule, which is set out in a document called Islamic Distribution of the Estate. It's attached to the form Islamic will that we have. We'll talk about Islamic wills here in a second. We're almost done. You can have the distribution schedule be whatever you want it to be. You want the distribution to be in accordance with Islamic distribution? Absolutely perfectly legal in Texas. You want to put conditions? Absolutely perfect in Texas. Islam allows you to gift away a third of your estate. Absolutely legal in Texas. You can gift it to an institution, you can gift it to individuals, or you can gift it to anybody you want. Texas allows you to also gift. For instance, you have a car that's very sentimental, or a piece of jewelry, or some clothing. I want to give to my uncle. Absolutely legal. You identify, as long as it's specific, and for it to be enforceable, it has to be specific. How do you know if it's specific? If 10 people reading it come to the same logical conclusion that that's what he meant. So in other words, you have to be real specific, real clear. I want my blue Thunderbird 1969 to go to my Uncle Ali, who lives in Plano, Texas. And you know, you can even put the last four of the VIN number is such and such. No one can argue with that. That's specific. Your Uncle Ali is going to get that upon your death. Ladies can say my jewelry, but be specific. Not all, unless they're giving all my jewelry to my daughter Haya or my daughter Razan or whoever. If you're going to divide it between different people, be very, very specific. Texas law allows you to do that. So, you die without a will, distribution in accordance with Texas law, very controlled, expensive, time-consuming, very stressful on the people that you leave behind, your loved ones. You die with a will, you can have an independent or you can have a dependent administration. You have an executor who takes care of your last rights. You have a trustee that takes care of the money that you leave behind. And in your trust, you can decide. You can give leeway to the trustee to say, I don't want you to sell anything. I want you to take the money and spend it on my kids. I want you to keep the property going. Sadaqah jariyah. I want to donate my house to XY ISNA or IANT or EPIC or MLF, whatever cause. And I want it to be used in the money used in perpetuity in my name or my wife's name or my dad's name or my mom's name to help XYZ, orphans coming into this country or so-and-so. So you can do that. So you build the will, executor, trustee, and guardians. You have the special gifts, you know, jewelry, cars, clothes, whatever you want. And then you have up to 1/3 that you can gift away in accordance with Islamic principles. Or you can just leave the Islamic distribution schedule. Or if you want, you can have your own distribution schedule. I want to leave everything to my wife. And upon her death, I want to leave everything to my kids. And upon their death, I want it to go to XYZ. Absolutely legal in Texas. So, let's go to the next slide. So what do you do? What do you do when you have a will? Just to summarize and finalize. I know this was going to be a longer program, but I think because the topic matter is very dull, and it's death and taxes. Oh, let's talk about the issue of taxes. You want to put up that? The highest amount of tax in our country is the death tax, 40%. 40% of a certain amount is taxed. If you have more than this property, you pay 40%. The capital gains tax is only 20%. The personal income tax is layered, but the highest is 39.6. Most people pay less. Corporations pay nothing. Elon Musk pays zero. He says he pays $11 billion. But the highest tax in our tax code, more than the capital gains, more than the personal property, more than the real property on your house, 40% is the death tax. This is a chart that's provided by the IRS. The interesting thing about the death tax is this started in 1916. Congress decided we're going to tax death. And when they did that, they cut this provision to where it's 40%. And it's, it's always a struggle between liberals and conservatives, people with money, people without money. And so in the early 2000s, when our country went conservative, there was a lot of legislation. A lot of you have probably read. We did away with the death tax. It went to zero. Congress passed the law. Death tax is gone. You don't pay anything. And then in 2010, there's some unemployment act or whatever. Congress brought it back. So now it is 40. It's back and it's 40%. But what's important with regards to the death tax is the exemption. When I started practicing law, the exemption was $400,000. In other words, if all of your properties were less than $400,000, it gets transferred to your heirs at law, no taxes. Alhamdulillah, now as you can see, it's 11,158,000. And that's for a single person. So if you're married, you double that. So unless you have a huge estate, over close to $22.5 million, you don't have to worry about the death tax. But with today's inflation, with the costs of real estate going up to where now a regular house is worth $1 million, some people have to worry about it. If you are getting to the threshold where the death tax is an issue that you must address, then this talk isn't for you. You need to go to an estate lawyer. You need to develop an estate plan. And those are simple. Those are easy. Well, they're not easy, but they're simple. You can develop a plan to where you put a family limited partnership or a family trust, and you transfer the property out of your name and you put it into an entity. That way you don't own it upon your death, the entity continues. And there's ways to organize that. Now, what happened with the smart people and the rich? What do the rich people have? Money. And when they have money, they probably have a lot of time. So they lobby Congress, and they come up with this idea that, before I die, I'll just give everything to my kids. I'll gift it. So Congress They want more money. They established a gift tax, and it's also 40%. So if you gift, and the amounts fluctuate between the years, you can see the gift tax from 2 million to 1 million. But the important thing to remember here is you can gift annually to anyone you want, including your kids. Each spouse, $15,000. Anything above that gets taxed. And you have a one-time, lifetime gift of $5 million. But if you gift more than that, it's taxable. If you gift more than $15,000 a year, it's taxable. Okay, finally the smart people said, okay, well, you know, Congress, I'm smarter than you. I'm not going to gift anything to my kids. I'm going to gift it to my grandkids. I'm going to skip a generation. So Congress passes the generation skipping tax, and it's taxed at 40%. So even if you gift it to your grandkids, if you don't do it right, you'll still get hit with a 40% tax. So, in conclusion, so I know a lot of you have questions, specific questions. I'll answer them. If you have a will, it's more predictable. You avoid putting a lot of stress and a lot of duress on your loved ones after you, and they don't have to go to lawyers and pay money. It also gives certainty as to how you want your estate distributed, and it gives certainty as to how you want to be buried, where you want to be buried, and who you want to pay all your expenses. Takes away all of the guessing. Avoids the death taxes if you do it right. You can make the special gifts, family heirlooms. You can make contributions to charity or donations that you want through your will, all perfectly legal. You can choose your executor, your guardian, and your trustee, and you make the choices there, and saves you a whole ton of money on lawyers. So you have a will, you take care of all of those things, and you don't have to worry about having to go through the probate problem. This is a very short summary of why you need a will, what the will does for you, how it protects your loved ones after you pass, and what you can do to custom make. You sit down, you think about, and you custom make how you want things to be. Say you have a will, you've prepared one. Can I supplement and modify my will? Absolutely. Like the Sheikh said, like our Amir said, you could do it daily. What if I'm out of town? What if I'm away from my lawyer's office? Fine. Texas law allows you to have what's called a codicil. Codicil is you have a will, and it's signed and notarized. You can have a codicil as long as it's in your handwriting, dated and signed, that says what's important for you to give property. You have to be knowing what you're doing, because what's the number one thing to a will contest? Bad story, but is he didn't or she didn't have the testamentary capacity. In other words, they were out of it. They didn't know what they were doing. You know, you hear all the stories about the billionaires or the oil tycoons that gave everything to the 20-year-old girlfriend, or the guy in Houston that owned, billions and gave everything to the new wife, and the old wife and kids got nothing. After years and years in courts and litigation, they settled, but you can do away with all of that. You can handle everything. You can customize it the way you want it, and you can do it in a way to save your loved ones all the time hassle and stress. Let me close right there, because then if I go on, it'll take forever. So you can have a will, has to be in writing, signed. If you have it notarized, you can have your executor be independent, and if they're independent, they don't need court approval to do anything. They just go in to the court and they get what's called letters testamentary. Letters testamentary is just a document signed by the judge that just says it's a power of attorney. That person you designated can do everything. Buy, sell, transfer, go into your bank account, go into your safe deposit box, sell your car, sell your stocks, but the will restricts what they can do with the money. Give it to your kids, give it to your wife, everything of that nature. I will stop right here. We've got a couple of minutes. for questions and answers. And so if you have a question, I'll be glad to address it. Sheikh Saad. Go to the slide with the hadith.
Islamic scholar who come and explain it from the point of view of Islam. In terms of what, like, you cannot give more than 1/3 of your wealth. Like Islamic, you can give 1/3, you can give less than 1/3, and it's up to you to whom you give. Also, you cannot say, I will keep, let's say you have $100,000. You cannot say, I will give my daughter $50,000 for her college, and you have another 5 kids, and you deprive them from part of your, that's not allowed.
Absolutely. What Sheikh Saad presents is absolutely necessary from a religious point of view. We must also understand that part. Everything I'm telling you is from a legal point of view. I am not a sheikh, I'm not a scholar. He is, the imam is, Sheikh Abu Ubaidah is, and they can address that. And I think in the future, to have such a program is an absolute necessity. Jazakallah khair, that is true. We need to have that so we can understand the Islamic perspective as well, brother. I'm sorry?
I'm sorry, I didn't finish it.
You have another question?
Very fast. Also, you mentioned if someone married from other faiths, that's allowed in Islam. But the father would not say, if you marry from the other faith, then I will deprive you from the shade that Allah gives. That's no, you cannot do that. Because this is not a reason for, the only reason that you're not getting the share is you become, you get out of Islam. So that's, and I will conclude with that. Can we have like, I'm afraid of wills, and I've been here for, alhamdulillah, a long time. And I get this will about 17 pages. And to me, I didn't read it. I don't want to read it. To tell you the truth, I have a lot of like Shakespearean language.
Sheikh Saad, you're doing the program today. We'll do the program later. You have a question?
Yes, my request.
Yes, sir.
Can we simplify it, like 1 or 2, 3 pages?
I would beg you to read it from a Islamic perspective, and please give us lawyers your perspective, and I will be happy to simplify it, make it less, and make it more understandable. That's a good point. Yes, Jazakallah khair.
If I pass and I appoint someone to take care of my property according to Islam,
Yes, sir.
and I sign that,
Yes.
I have to give that person a power of attorney?
No.
Or the court will give him the power?
The court will give him power of attorney.
That person will divide my property according
To your wishes.
gives a wife, whatever, 1/3 or 1/6.
Exactly.
And gives the children according to the Quran.
Exactly.
Jazakallah khairan.
وإياك.
I really appreciate that.
وإياك شيخ.
It's
يعطيك العافية.
true, and alhamdulillah that we have.
جزاك الله. Can you
If you could cross-check, if you please highlight the trust, how the trust is different, having a trust-based wills versus the one you mentioned, the probate trust.
You're going to have to explain that.
You mentioned the probating, like if there's no will, the things will go to the court, and then right, and the court will decide. So there another way, right, that what I had from the other session, that if the person creates a trust, under the trust of the will, the trust will be the manage the property.
Yes. Yes, okay, Jazakallah khair. Yeah, if you have a will and you have minors, you set up a trust, the trust will control how your property will be dealt with for the benefit of your kids. Although you may go to probate or not go to probate, the trust will control. And you can make just like the will, you can make a simple trust. I want everything to do with my kids when they turn 18, and I designate my brother Muhammad to be the trustee over this estate. Or you can make a complex one, or you can make a custom one that says, I want my brother Ali to be the trustee, and you can put more than one trustee. Some people with huge estates, they put bankers as their trustees, or lawyers, or CPAs. And you can designate whoever you want to be the trustee, and you can put conditions in the trust. And that trust does not have to go and get court approval from the probate judge. As long as you wrote it and it's specific and enforceable, that's what happens to your property for the benefit of your kids. All the adults will take their portion upon death, upon the will being executed, but the trust will control what happens to the kids without probate court interference. If you're married and your estate is below the $22.5 million exemption, you don't pay any taxes. If your estate is going to be more than that, then there's lots of ways to avoid it. The number one way that I described when I was talking is to set up a family living trust. In other words, let's say you have an asset that generates $1 million a year. You have the ability to transfer that property out of your name into a company, a trust. And you designate who runs it, the trustee, and you designate who the beneficiaries are, your children. So this trust is an entity. You can even think of it as it's a person. It has its own tax ID number. It files an annual tax return. It has bylaws. It has management, the trustee. And you put the conditions of the management. You say, I don't want them to sell anything. I want them to use the profits for the benefit of my children's education, living, expense, everything. And you can put special conditions. So there's many, you can do a family limited partnership where you're still in control, but you give shares to your family. There's many vehicles you can do to avoid the death tax. Yes, there are ways. That's enough. He says his wife has had 2 strokes and she can't write. So you're asking if you can do a power of attorney without your wife having to sign? Yes. Okay. From what I understand, what you can do is you can videotape her in front of a notary. Can she talk? Yeah. Then you can verbalize it, and she can with her thumb, as long as it's videotaped and the notary is there, and the notary gets it on video, then yeah, it's a valid power of attorney. She doesn't have to sign. It doesn't have to be a signature. So it could still be valid. But even if you have it on video, when she's attempting to sign and someone is helping her, but she verbalizes, I can't hold the pen, he's only helping me to hold the pen, but I'm signing this voluntarily of my own free will, and the notary public accepts that, then it's valid. It wouldn't be clear. Brother, we have people from all different parts of the world that sign in their native signature in whatever language you can think of, and it's accepted in the courts. As long as the notary accepts it and notarizes it, she signed in their presence, it's valid. 100% valid under the law. Yes, sir. Alaykum as-salam wa rahmatullah. Good question. And I'm sorry I didn't address it in the main topic. Islamic wills are valid under Texas law and will be accepted by the courts. So a simple Texas will is a will. A Islamic will is a will. As long as it's in writing, signed by the person who is the testator, the person that wants to, and it's signed by two people, and if you want an independent executor, it's notarized. If you meet those conditions, it's a valid will. Texas recognizes Islamic wills, so they are valid. Yes, brother. Good question. It's preferable for them to be here because they have to do such things as, go to Restland or go to Rahma and sign contracts and pay fees. So you need to pick someone who is local. The questions I get is, can I, pick my brother in Louisiana or New York? Yeah, as long as they can come on a moment's notice, because they have to go talk to people, pay bills, get credit cards, do those kinds of things. So it's preferable to have somebody local. It's valid if you sign it and there's two witnesses that watch you sign it and they sign. It does not have to be notarized. The notary portion is if you want to appoint an independent executor, then the will has to be notarized. Bro Hanif. Assalamu alaikum. Yes. Yeah, they're two different things. The wills that we're talking about are the wills that when you die and you leave your property to your loved ones and you leave instructions as to how you want to be buried. The living will controls what's called end-of-life decisions. End-of-life decisions in terms of pulling the plug. And usually those are for you to make a decision as to whether you want to go on life support or not. And then if you do go on life support, who makes the decision? Is it just your wife or your kid or your doctor or three of them? So yeah, that controls end-of-life decision. This controls post-death. Any amount of money you have, you can form a trust. If you have children under 18, you have to have a trust. You can't give them the money. Minors can't take property in their name through your will. So even if you have $50,000 or $20,000 in your estate, if you have a wife and kids, the kids' portion has to go through the trust. It's not a formal, it's just the trust in your will. Now, there's a separate, and here it gets a little more complex. You have a trust, which is a valid legal trust in your will that says my kids take when they become 18 or 25 or whatever you decide. Now, you can set up a trust outside your will. Whether you have a will or not, you can set up a trust. A lot of the big athletes and big companies, they have their foundations. They're usually in trust. And the trust, like I was telling the brother, is a separate, it's like a corporation or an LLC. It's a separate legal entity that has its own tax ID number and it has bylaws and constitution. And then everything you put or transfer into the trust belongs to the trust. And again, this gets a little bit more complex, but you can have a revocable trust and an irrevocable trust. If a lot of people that have a lot of money and they're afraid of getting sued, they established an irrevocable trust. Irrevocable trust is an entity that cannot be penetrated. In other words, you have a $10 million business. You transfer it into the irrevocable trust. Once it's into the irrevocable trust, that's exactly what it is, irrevocable. You cannot get it back. It's into the trust. The trust owns it. You can appoint the trustee and you can make sure that all the benefits go to your beneficiaries, but you can't come back and own this and say, oh, 10 years from now, I want to sell it. You can't. The benefit of that is it has all the asset protection rules known in the law. It cannot be penetrated for creditors. Somebody that has a judgment against you can't come and take it. So this is a complex trust. The trust in your will is a simple trust. It basically says, I have kids, when they're 18, I want them to take their portion of the estate. Excuse me. Tfaddal. Sheikh Saad, you go next.
Say you put your first executor as your wife.
Yes.
You put a friend or a family member next.
Absolutely, yes. Executors, you can make the decision whether you want them to be independent or dependent. Independent means they don't have to go get court approval. Dependent, everything has to go through the courts. The first one can be your wife, and then you can have backups just in case she predeceases you or she's ill or can't serve. Then you have the backups, and you put the backups so you don't have to go in every year and change. So you can put my wife, then my brother, then my sister, then my son, and have all those backups.
I'm a notary public. Can I sign the will and two witnesses sign and then I notarize?
No,
I cannot do
no, you can't notarize your own signature, no. Has to be a different person. All right, we have one more question. Two more questions. No, you go, brother. Jazakallah khair. Right.
Sometimes the people say we have to go to a lawyer, to attorney will do these things. Are you doing this? If you make the appointment with you are doing this job or not?
We will if you have issues, but if you don't have issues and you don't have over 22 million, you don't need a lawyer. You can fill that out and sign it and it's valid. Now, some people have, when I say issues, say, okay, I want to make a special trust, or I want to make a special gift, or I want to make, I have something more complex. Then you probably need to come to a lawyer. Do I do this? I do, but I don't like it. I'm an injury and accident lawyer, and I'm a business litigation lawyer. But I have done wills for many prominent people in the community, so I do it if I have to, but it's not my specialty, or it's not my, but if you fill that out, it's valid. You don't need a lawyer unless you have something very specific and special that you want to do. Salam. Oh. Community property. Okay, good question, and I use my hands. We Arabs are very, yes, all of us are, but community property, date of marriage to DM to DD, date of marriage, date of death or divorce. Everything acquired between this two brackets is community property. You don't own it 100%, and your wife doesn't own it 100%. But you own, now I'm going to confuse you even more, but you do own 100% undivided interest. Okay, what does that mean? It means that you and your wife own it together. Can you give all 100% of the community away in your will? That's that chart that Muhammad put up. You can only give away your portion of the community. Say your portion of the community is 50%. That's what you can give away. Your wife can give her portion. Say you pass away your wife is alive, and you give your portion to your wife, she owns 100% of the community now. Then she can give it to the kids or to her family or whoever. So we had this problem for hundreds of years, which is called the common tragedy problem. May Allah protect you, but say, not you, say somebody is traveling and they die in a common disaster, airplane crash or railroad crash or something, and the wife and the husband die in the same event, but the doctors determine that the wife lived more than a minute or 5 minutes than the husband. Then under the scenario I just described, you both have wills, your portion of the community goes to your wife, she owns 100% of the community now, then everything gets distributed in her will. Perhaps she gave 50% to the kids and 50% to her brothers and sisters. In your will, you might have given it to different people. So now Texas law addresses this dilemma by saying that to be a surviving spouse, you have to survive more than 30 days. And you can only give away your portion of the community, and she can only give away her portion of the community. The exception is, what we put up there is if you have a house or real property, because again, it gets real complicated. And under community property, you have personal property, your car, your clothes, your jewelry. You have real property, your house, your land, if you own shopping centers or office buildings, and those are treated separately. Your wife has a life estate. If you have a house or property, your wife has or you, if she dies before you, have a life estate in the real property. In other words, you pass away, your wife can't sell the house, but she can live in it for the rest of her life, then it goes to the kids. So community property is real complicated. It takes us 3 years in law school to study community property, and we graduate and we still don't understand it. So, but the simple answer is I made the statement about Balfour giving away Palestine, giving away, just to make the point is you can't give away what you don't own. So you can't give away 100% of the community because you don't own 100% of the community. You may only own 50% of it. So you give away your 50%, she gives away her 50%. What was the first part? Yes. Yes. The beneficiaries you identify in that plan control those funds that you have in that plan. And when you get to a certain point where you need to do estate planning, it's good to keep all of that retirement money. You know, you have all of your assets. You don't want to pour all your assets through probate. Because of what? Your executor's got to go through everything and account for it, got to file a tax return, got to, if it's dependent, got to get court permission to do everything. If this stays out of your probate, your beneficiaries get it directly without having to worry about the death tax, without having to worry about probate, without having to worry about probate lawyers. They get it directly. So you keep all of this stuff outside of probate. So your beneficiaries get it in accordance with your plan. Last question, bro.
You mentioned that you have to have a trust if you have kids under 18.
Yes.
Suppose if somebody died and unfortunately he did not establish the trust, what would happen next?
He dies and he doesn't have any children?
He did not establish the trust. He died and he left behind children under 18. And there is no trust in place.
That's a great question. You do the will now and you have kids later. Texas law fills in the gaps when there's something missing. There will be a trust established for you, but guess what? It won't have any special provisions. It'll be just a simple, you died, you have kids get the property under whenever they turn 18. So yeah, that's a great question. But it also raises the question of, and we have it in the sheikh left, bad, because we have the question under the law and in the Sharia, what happens if you have kids and your kids died in your lifetime, but they have kids, do they take? Do they not take? Does the whole estate go to the other kids? That is a debate within the law. Now, the good thing is about Texas law is if you have a will, you can control it. You can say, I have 3 kids. I have Layla and Muhammad and Jamal. And I want my 3 kids to take equally or to take under the Islamic distribution schedule. But if one of my kids dies within my lifetime, I want their kids to inherit their portion. And I think, and I'm not a sheikh, that's why maybe Brother Abu Ubaidah, Sheikh Abu Ubaidah, who I love dearly, could address that. But under the law, it gives you the right to designate who takes, and you can address that. Sharia-wise, I don't know. So that's the simple answer. Okay, last. It's 3 o'clock. I promised the brothers would be done by 3. Tfadla. Yeah, yes, go ahead. Yes, sir. On the death of the second spouse.
That's it.
Yeah. Yeah, everything becomes known on the death of the second spouse. You can, but that's called a post-nuptial agreement. You can do it by post-nuptial, like a partition agreement. Yeah, it's a different document. وإياكم. I'm sorry we didn't use all the slides. I just went.
I was waiting for something like this for so long.
Jazakumullah khairan everyone for attending, and may Allah reward Brother Khalid for spending his time and educating us. This is obviously was very beneficial. Inshallah, we will have a follow-up session from the Sharia perspective. Jazakumullah khairan.